Well, thank you very much. As he indicated, this was scheduled for 8 o'clock and was adjourned to this time. I was here at 8, but it's a challenge to bring people together on a Saturday morning at 8 o'clock. As you know, I've been an international prosecutor and a national prosecutor, my own federal system in the United States, and then as senior trial attorney and chief of prosecutions at the International Criminal Tribunal for Rwanda and Arusha for almost 6 years, and then 3 years as the chief prosecutor of the Special Court for Sierra Leone with trials in Freetown and, of course, also the trial of Charles Taylor in The Hague. And for the last 15 months have been the ambassador at large appointed by President Obama dealing with the issues of mass atrocities. And it's a great honor for me to be here today at the Achebe Colloquium, celebrating the 80th birthday of the great Chinua Achebe, and to be asked to keynote it is a real dream. When I heard that I could give a keynote address, I asked for the theme of this year's conference and was told it was strengthening democracy. And you should know that my current position is not the position in the State Department works directly with democracy and general human rights issues. It deals with the United States response and the ways that we work with other countries to respond to the most serious violations of human rights, mass atrocities, the intentional targeting of innocent men, women, and children for lethal violence and rape and mutilation, for genocide, crimes against humanity, and war crimes. And so the question may arise, what's the relationship between democracy and these issues? And I think we can probably begin with the sad irony that democracy in the form of all or nothing elections too often, and particularly when it's in a system that doesn't provide for enforceable protection of minorities, too often is accompanied by attacks on innocent civilians and sometimes by mass atrocities. As I indicated, I spent 6 years prosecuting in the Rwanda tribunal and led the trial of the media leaders, Hassan Ngeze, the editor of Kangura, and Ferdinand Nahimana and John Bosco Baragwiza, who we alleged were the number 1 and 2 in charge of Radio Televisión Libre de Mil Colleen, RTLM radio, often called hate radio. And of course, in trying to understand the Rwanda genocide, one came to the recognition that it was accompanied, that the development, the dynamic that led to the genocide was accompanied by the advent of multi-party democracy in Rwanda. And that in 1990, Habyarimana and his narrow regime concentrated in terms of who had the power and the wealth and the positions with people from northwest Rwanda, and Akazu as it was called, was facing two challenges: the RPF attack, to be sure, but the pressure post-Berlin Wall, and with the Francophone world asked by Mitterrand at Laval to move toward multi-party democracy. He was looking at the danger that a democratic opening in his country would empower his Hutu opposition, the people who he'd overthrown in 1973, and Hutus in other parts of the country, and the danger that they would make common cause with the RPF was the greatest danger that he faced, not just in war, but in any kind of democratic election. So the dynamic that one saw, at least that we presented in our case, involved first and foremost Kangura, that began beating the drum of demonizing the Tutsis, saying that they're the enemy. We have to unite against them. Writing in the Appeal to the Conscience of the Bahutu in December of 1990 about how the Tutsi had from the beginning used their women and their wealth to undermine Hutu strength, following with the Hutu 10 Commandments that said that anyone that makes common cause, anyone that employs, anyone that has a relationship with the Tutsi as an enemy, a traitor. And following in Kangura number 26, with the very interesting cover that asked the question, what weapons do we need to defeat the Inyenzi and Tutsi once and for all and win the 1959 revolution? And the Inyenzi, of course, being the cockroaches, and Tutsi obviously referring explicitly to the ethnic group. And the two weapons were the machete, and there was a picture of Kayibanda, overthrown in 1973, but still most memorable for his Parmehutu party, for the massacre at Gikongoro of 10,000 men, women, and children in 1963, and by his prediction that if Tutsis tried to come back to Rwanda, there'd be a genocide. And then following in other media and in RTLM, the drumbeat that the majority people need to exercise the majority, that the republic means Hutus control, and Hutus should unite as a single man. And then with the advent of RTLM, interestingly, the drumbeat is not, at least initially, heavily against Tutsis. It's against the moderate Hutus. They're the ones that are demonized and attacked. And with some success, creating a split within the Hutu parties, a power movement in each party that allied itself with the Habyarimana party, culminating when that constellation successfully blocked the implementation of power sharing and democracy with the events of 7 April, when all of the moderate Hutus in the government were assassinated and replaced with extremists, and empowered those who saw the need for total war, the destruction of the Tutsis, and followed really the logic of the rhetoric that this political campaign had led to. More recently, in Kenya, we saw in the end of 2007 an election fought to a near tie along an ethnic fault line, followed by violence that saw the murder of 1,133 people, violent youth, armed and incited and sent out to burn and to hack the flesh of innocents. One group aggrieved because the election was stolen, the other aggrieved because their people were being attacked. A close-run situation with all the intervention and particularly with the good offices of Kofi Annan and everyone working together, eventually contained, though threatened again in 2012. And then this week in Cote d'Ivoire, an election won by one man and claimed by another. I just saw coming over the wire on my phone that Laurent Gbagbo, the winner of 46%, was just sworn in for a fifth term as president and is sending forth thuggish youth to attack foreigners, as so-called, as those that would prevent Ivorians from deciding their own future, a future, of course, that they decided by a majority vote to the contrary. And that will take all the world's efforts in the region, in Africa and elsewhere, to contain. Well, what is the answer to these kinds of incidents? Of course, it's not to reject democracy. It's as much as one can idealize traditional forms of rulership. We're talking about multi-ethnic, multi-religious, regionally sometimes divided states where one person's traditions are not the same as the others. One needs a government based on the consent of the governed with protection for all. The Kenyan Constitution enacted, ratified in August, promises something closer to balance of power, checks and balances, separation of powers. We'll see how it works in practice, but to avoid the elections being all or nothing sort of situations, to ensure that the interests of all are protected. But of course, this isn't my jurisdiction. Mine is justice. And the question is, what can international justice, the project that the world picked up after letting it lay for 45 years after Nuremberg, the project the world picked up again in 1993 with the Yugoslavia Tribunal. What can be done in the sense of sending in investigators and prosecutors and judges to bring accountability for perpetrators and hopefully deter these kinds of acts? Well, first of all, we know what kind of justice we don't want and that won't work, and that's the kind described in Things Fall Apart of courts with a district commissioner who rule in ignorance, of courts staffed by foreigners who are arrogant and high-handed. And of course, that's how some of the people targeted for international justice prosecution who face arrest warrants characterize it. No matter how covered in blood of innocence they may be, they say this is unjust because others have gotten away with it. But that's not what we hear from victims. They want justice. It's the cry for justice, not the actions of great powers that led to international justice coming on the scene and growing since 1993. At that time in Sarajevo, the innocent Bosnian Muslims were being bombed in their markets, shot down on the way home from school along Sniper Alley by Serbian nationalists who were trying to drive them out and ethnically cleanse eastern Bosnia. An international court was established. The world wasn't ready to send in troops with robust forces with a mandate under Chapter 7 to protect individuals because of the risk that would essentially occasion to those that went in there to do the protection, but decided to send in lawyers and judges instead. And the following year in 1994, when perhaps at least 5 times as many people were murdered as in all of the atrocities in the former Yugoslavia, what's generally viewed as at least 500,000, perhaps up to 800,000 within 100 days of 1994. The call was for the establishment of an international tribunal for Rwanda. How is it that there can be a court when the victims are European, but there's not a court when the victims are African? And that pressure led to the establishment of the International Criminal Tribunal for Rwanda, where I worked for 6 years. The ICC, which came on the scene in 1998 with the Rome Conference, was not the project of big powers. It was something in which smaller powers, in which Africa played the key role. And today we have a situation where the ICC has been ratified by a larger percentage of countries in Africa than in any other continent, where 5 of the 18 judges are African jurists, where the deputy prosecutor is an African, and it is almost a lead pipe certainty that the next prosecutor elected in a year in December will be an African. And in Sierra Leone, the Special Court for Sierra Leone was established. It was called for a year after the Lomé amnesty, when those that had been hacking off limbs of thousands, killing tens of thousands, raping hundreds of thousands, were given a full amnesty, but didn't live up to the amnesty, didn't disarm, attacked and murdered African peacekeepers, and a group of citizens marching on Spur Road toward the home of Foday Sanko, who'd been rewarded with the effective vice presidency of the country under power sharing and control of the mines, protesting the attacks on peacekeepers, were shot and killed by his bodyguards. The demand then was from Sierra Leone to the international community to join together to establish a court which would judge those who bore the greatest responsibility for these atrocities, but in a new way. Not a solely international court, but a partnership where the court would include both national and international personnel. A majority of the judges appointed by the UN, a minority appointed by the government, prosecutor appointed by the UN, a deputy by the President of the Republic. The question, of course, is, have these institutions been successful? Have they lived up to their promise? And one hears constantly of the complaints of cases that are too slow, procedures that are too cumbersome, things that have not fulfilled everyone's expectation. Though when I'm in New York at the UN, the complaints come most often from the Japanese and others concerned about their costs, and rarely, frankly, come from the countries where the victims are the victims figure. The Yugoslavia tribunals judged about 150 people. So if people say most of the people judged by international justice are in Africa, that's not true. The courts together in Africa so far have judged about 70 or 75 individuals, most of them in the Rwanda tribunal, which has been successful in bringing those who led the genocidal regime to trial. Arrests in 26 different countries, 15 of them African, of 13 military leaders, including Colonel Bagosora, the strongman of the genocide, 12 government ministers, including Prime Minister Kambanda, who pled guilty to genocide, the leaders of the media that I prosecuted, the territorial administrators, clergy, business leaders, others that in the view of the prosecution conspired together to commit total war against Tutsi civilians. Sierra Leone has been a different experience, and in many ways one that has been perhaps more productive. It employed 60% of its staff were Sierra Leonean. It had an outreach program entirely populated with the Sierra Leoneans, with district outreach coordinators who were Sierra Leonean in every part of the country, who conducted hundreds of meetings describing what the court had done. And even while the numbers prosecuted have been only 10, 3 groups of 3 militia leaders each on opposite sides, and Charles Taylor, because of the magnification of its efforts, and of course that was required by its limited mandate only to go after the senior leadership, it's had an impact. When I was there before the election in 2007, I remember seeing a headline in a newspaper, and I was wise enough not to contest it. It read, "Special Court Investigators investigating election violence." And I thought, well, that's a little outside our jurisdiction. But I continue to hear these reports that we were on the case and that if there was violence during the election, the special court would be out there prosecuting it. The perception had at least been gained that now, if there were violence, there were going to be consequences. And as you know, the Sierra Leone election was fought, and fought to some extent, though it's not a very sharp divide, along the sort of northern and southern Temne Mende line of the savannah and the forest, and with the opposition winning the election and being allowed to take power without any lethal violence. However, I have to recognize that particular Sierra Leone experience and the others are far from perfect. And that brings me to the situation of one of the countries that this conference is focused on, and that's the Democratic Republic of Congo. I just took my 5th trip since I had this job to the Congo this last week, and was in a session for 2 days with government and civil society people in Kinshasa on Monday and Tuesday, discussing the response to the mapping report and the atrocities that have been documented by the High Commissioner for Human Rights for the period of 1993 to 2003. The direction of that effort is now to establish not an international tribunal, not a hybrid tribunal, but specialized chambers within the Congolese justice system, where perhaps one foreign judge would sit with 4 Congolese judges to deal not just with the cases between 1993 and 2003, but also with the serious cases after 2003 of leaders up until the present that haven't been brought to justice by the ICC, and are beyond the reach of the Congolese military justice system as it stands right now. This would be a 10-year process that would phase out the internationals And it offers, I think, the prospect that what's done will have a larger effect within the society itself. It was one of the unfortunate things in Sierra Leone, perhaps because of the Lome amnesty or other reasons, where there was no national prosecutions or no effective national prosecutions for the atrocity crime. So there wasn't any of the sort of complementarity that one wants to have where the internationalized court works with the national system to strengthen it beyond the training classes and other things that we did. And there has been success with the ICTY and building up the prosecutors in the former Yugoslavia. And we would hope that the ICC could do the same thing in places where it has a situation, such as the DR Congo. But frankly, if you follow the ICC debates, they say they have enough on their plate just doing these international cases. They're not a development agency. They can't help build judicial systems at the national level. That critically needs to be done. And so part of my commitment and my boss, Secretary Clinton's commitment, is to do everything we can to strengthen the national justice systems, but to help provide, in particular, the capacity, but also, by the temporary placement of internationals, some of the independence that the victims seek to ensure that, that those that are well connected that may not be subject to justice now could be fairly judged. But that in the process, one could strengthen the kind of judicial system that's necessary if democracy is truly to be strong, because a necessary part of that has to be a judicial process that operates without fear or favor. So that's how I see the direction of international justice, with the promise and indeed the expectation raised by victims that powerful people will be brought to account, and certainly the necessity, when there's no capacity and no will, to have international institutions. But the migration of the resources and our efforts has to be to put it where the victims are, to put it where the affected communities are, and to ensure by doing that a future where others won't be faced with the same kinds of horrendous crimes that have occurred in Rwanda and the DR Congo and elsewhere. So thank you very much.